When a disabled person submits an ADA request to the Disability Access Coordinator, they are not requesting access to a specific judge. They are simply requesting access to the building, the courtroom, and the goods and/or services offered, visual, audio, or otherwise, therein. This request has nothing to do with which judge happens to be sitting on the throne, but rather what accommodation the building has, or does not have. Elevators, laptops, cameras, internet access, wide enough doors for a wheelchair to pass through, and so on. If the facility is lacking in needed accommodation, the Disability Access Coordinator must facilitate obtaining the needed accommodations to allow the qualified person with a disability the same access as everyone else in the necessary format. The broadness of the scope of these requests cannot be overstated. Each person is different. Each disabled person mitigates their disabilities in different ways. The DAC must first find out the needs of the individual and go from there, maintaining a dialogue with that individual throughout the process and deferring to their needs above the public entity. That said, once accommodations have been made to allow access to the facility and the goods and services offered therein, a different employee can't just come along and revoke those accommodations. In order for an accommodation request to be denied in the first place, the denial must be issued in writing by an administrative head and must demonstrate, and not merely state, that the requested accommodation would fundamentally alter the goods or services offered or would be an undue burden to the entity. Again, this must be demonstrated and not simply claimed. More specifically, it makes no sense and appears to run completely contrary to the ADA for disability access accommodations to be given or taken away at the whim or preference of whatever judge sits on the dais. If a judge does not feel comfortable granting the necessary accommodation to the person with a disability, then, out of the abundance of caution, and to avoid any appearance of bias or prejudice, the judge should recuse themselves from hearing the case and allow a different judge to step in. It is not called the Judge Stewart Albright Courthouse or the James E. Hardin Jr. Justice Center. It is the Superior Court of Rockingham County. If a court cannot provide equal access, they are not offering due process. If there is no due process, there should be no prosecution. If you need to catch up, just check the description for the link to the playlist and pick up where you left off. Now let's get to it.
You shut down Google if you need to shut down Google.
After Judge Albright made an utter mockery of justice and due process, denying Mike equal access and spotlighting the disabled man in court for hours, Mike began the process of appeal. He appealed the administrative issues of accessing the courts via the administrative route and via the judicial branch. Please check Part 13 for the details of that. That court granted the remote hearing via WebEx and funded IRA visual interpretation services. In so doing, the courts demonstrated that there is no undue burden or fundamental alteration to the proceedings in granting such requests. Everything in the Rockingham County criminal case was put on pause when Mike filed the appeal of Judge Albright's discriminatory and unconstitutional orders. Finally, after the Supreme Court of the United States, SCOTUS, refused to hear Mike's case, the criminal industrial complex grinder started turning again. Now, since the higher courts couldn't be bothered to step in and correct the lower court Judge Albright's discriminatory actions, it seemed like the courts would have a renewed and inflamed vendetta against Mike. As soon as he learned that the appeal was resolved in November of 2023, Mike reached out to the prosecutor, Cockman, to at least get the bond motion before a judge. This way, perhaps Mrs. Nelson could at least recoup that $50,000 and pay off the loan that she took out to rescue Mike from isolation in a maximum security prison back in October of 2020. As of September of 2024, she has paid over $10,000 in interest alone. Cockman said he was waiting for the appeal to make its way through the higher courts, but once it did, he would gladly calendar the bond hearing. In March of 2024, Mike had still not heard anything from the Rockingham County Court about scheduling his case. He reached out again and finally got a date for a hearing. There are still multiple pretrial motions on the table to be heard. One is a suppression hearing, which could take a couple days, any of which could dispense with the whole case and set Mike free from these shackles. Mike again submitted his ADA request for equal access, like they have made him redo every hearing. This time, Mike was able to reference the precedent set by Judge Class in the North Carolina Superior Court in Guilford County, granting all of Mike's ADA request and not fundamentally altering the nature of the services or causing an undue burden to the court. After granting an accommodation, an entity cannot legally just revoke it willy-nilly. Accommodations are not to be granted or withheld based on the emotional state of the person hearing the request. The entity is supposed to give priority to the disabled person and what they need. Disability accommodations are not preferences. These are requests that make it possible for the individual to function and participate in the goods or services offered. A public entity must accommodate the individual. If they cannot fulfill a specific request in the exact way requested due to an undue burden or fundamental alteration of the nature of the services, they are supposed to enter into a dialogue with that individual to find a solution that will still meet the person's needs, not just deny the request. Basically, it is the Disability Access Coordinator's affirmative duty to find a yes. Disability requests are not static. A disabled individual's need may shift and change over time. Some conditions get worse and require more accommodation. The disabled person cannot be forced to accept the level of accommodation offered, even if they previously accepted it. Well, they cannot legally or morally. They can and do choose to trample all over the disabled population on a regular basis, and are very rarely called into account for their abusive actions. Check out the Supreme Court case, Tennessee versus Lane. Lane arrived at court in his wheelchair and discovered that the courtroom was on the second floor. The courthouse lacked an elevator or other accommodations to allow him access to the courtroom, so he was forced to crawl up the stairs in order to avoid being arrested for failing to appear. The next time Lane arrived for court, he refused to surrender his dignity and independence, refusing to accept the level of accommodation provided or not provided, and arguing that the lack of accessibility was a violation of his rights under the Americans with Disabilities Act. In true Tyrant fashion, the court had Lane arrested for failure to appear. The Supreme Court ultimately ruled in Lane's favor after the damage had been done. This ruling emphasized that states have an obligation to provide reasonable accommodations to ensure that individuals with disabilities have access to the judicial system. The decision affirmed the general principle that states must make public facilities, like courthouses, accessible unless they can prove that doing so would fundamentally alter the nature of the service or create an undue hardship. Okay, back to Rockingham County. Q. Judge James E. Hardin, Jr. Ignoring the previous gains Mike had finally received in accessing the courts and disregarding the Americans with Disabilities Act, the Due Process Clause of the Constitution, and much, much more, likely even his humanity, Hardin got his claws into Mike's case and seemingly decided to take a turn at punishing Mike. His tactic? Ignore Mike's requests and not engage with Mike prior to court other than to demand that Mike be physically present in the courtroom. Similar to how Jag-off Judge Chris Freeman acted prior to Mike's arrest on the courthouse steps on October 6th of 2020. Let's be very clear here. Mike cannot physically get to court nor into the courthouse if he made it all the way there. He cannot afford to fly. Taking a bus from his current location to court would take over 24 hours one way, and with the burden of that $50,000 ransom still crushing the family, he simply cannot afford even the bus. On top of the cost, it is highly likely that Mike would suffer a debilitating migraine in transit and not make it to his destination. According to Google Maps, the estimated time it would take to walk to court is 9 straight days, constantly walking, with no breaks or sleep, one way. And that is just getting there. If by some miracle he made it there, he would be immediately arrested once he arrived at the courthouse due to a warrant for previously not being allowed access to the Guilford County Courthouse, even though he was literally sitting at the computer ready for court, awaiting the link so he could enter the courtroom. Again, blocked from entry and then punished for not going in. Alas, Judge Hardin did not engage in a good faith dialogue with Mike to find a way for Mike to access court and instead chose to ignore the qualified person with a disability's needs. Judge Hardin made utterly inaccurate statements in his demand letter. Hardin claimed that Mike was contacting the courts about his ADA requests without the involvement of his retained counsel, Mr. Simmons. Mike has no retained counsel and is a pro se defendant and has been since December of 2021. Hardin demanded that Mike make his requests in the presence of said counsel in open court. Mike reached out to the disability access coordinators in an attempt to get them to coordinate disability access, but they did not respond to his pleas for help. FYI, ADA requests are administrative, so even if Mike did retained counsel, Mike would not have to go through said counsel to contact the courts about administrative access issues. Mike reached out to his auxiliary aide, Mr. Simmons, and the two worked to bridge the gap so that Mike could still try to appear in open court. Mr. Simmons had previously assisted Mike in the accessible proceedings in Guilford County and agreed to be at the courthouse on May 6th, ready to connect to Mike virtually, essentially opening the courtroom door and allowing Mike to be present in open court. On May 6, 2024, Mike was standing by, ready and awaiting entry, but the judge denied him access. He was informed afterward that Judge Hardin revoked the $50,000 bond money, issued a warrant for arrest, and increased the bond amount to $100,000. Anyone remember what charge Mike is actually facing in Rockingham County? It's a simple resist, delay, obstruct charge, which is a nonviolent misdemeanor with no priors, a charge that, if found guilty of a defendant, would be facing no jail time. Pretrial guidelines even outline that there is no bond amount, but simply a promise to appear. So now what? Mike has reached out to the NC administrative offices of the court in an attempt to get them to correct the access issues, but they are non-responsive. Mike has reached out to the clerk of court in Rockingham County in an attempt to get access to any orders or warrants that were issued by Judge Hardin and has yet to receive those documents. Mike contacted the court reporter to get the audio of the proceedings, as was ordered by Judge Albright in open court back in January of 2022, but has not gotten a response. What justice issue is being met by Prosecutor Cockman continuing to pursue this charge? Where is the victim of the alleged crime? All of the state's witnesses testified in the bench trial that they did not even see any criminal activity, just a van in a parking lot. The amount of punishment the NC court judges have dished out on Mike in this case alone is staggering. What is the justice interest in pursuing an obstruction charge against a blind man who lives and has lived in a whole different state for over 3 years? What is the point of continuing to pursue charges against a man that, if convicted, would result in no jail time? The same man who has already been under some form of incarceration for over 45 days, 10 of which were spent in isolation in a maximum security prison, just for trying to access court to dispense with the charge. So here we are. You're all caught up to September of 2024. If you made it this far, thank you. Thank you for watching, listening, commenting, and sharing. Thank you for your support and encouragement through this process. There will be a new update added to the Guilford County series about the warrant mentioned in this video, so be sure to watch out for that. In the meantime, De Oppresso Liber.